Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with an important update from the Supreme Court. In a significant judgment that reaffirms the principles of upholding the dignity, rights and well-being of armed forces personnel, the Supreme Court has ruled in favor of a retired air veteran, holding that Indian Air Force, IAF, and the Indian Army jointly and vicariously liable for medical negligence. The case relates to allegations of negligence by the respondents which led to the appellant, the air veteran, contracting HIV. While on duty under Operation Parakram in Jammu and Kashmir, he fell sick and was admitted to military hospital in the year 2002. There, 1 unit of blood was transfused into his body during treatment. Then in 2014, he fell sick and HIV was diagnosed. He had approached NCDRC claiming compensation for 95 crores but was denied. So he filed an appeal against the judgment of NCDRC before the Supreme Court. The Supreme Court said since individual liability cannot be assigned, the respondent organizations IAF and the Indian Army were vicariously liable jointly and severally. Also, the appellant has been awarded compensation amounting to 1 crore 54 lakhs and 73,000, which shall be paid by his employer Indian Air Force within 6 weeks. The court has also said that it is open to the IAF to seek reimbursement to the extent of half the amount from the Army. Not only this, but the bench comprising Justice S. Ravindra Bhatt and Justice Arvind Kumar has also laid down significant directives for the government, courts and quasi-judicial bodies under the framework of the HIV Act of 2017. For these, you can refer to our website at livelaw.in. The Supreme Court today referred an important issue with respect to arbitration to a 7-judge bench. The issue is whether unstamped or insufficiently stamped arbitration agreements are enforceable or not. A 5-judge bench led by the CJI Chandrachud made the reference while hearing a curative petition against its 2020 ruling that had held that an arbitration clause in an insufficiently stamped agreement cannot be acted upon by the court. If you remember, in April this year, a constitution bench of the Supreme Court had answered the reference in this issue and had held that arbitration agreement in unstamped contract is unenforceable. The bench said that an instrument which is not stamped cannot be said to be a contract enforceable in law as per the Contract Act. During today's proceedings, the bench remarked that it was too important an issue and had caused limitless uncertainty in the area of arbitration law and had to be considered by a larger bench. This was because older agreements were now being opened owing to being unstamped. Accordingly, the court directed that the matter should be placed before a 7-judge bench and the proceedings for the same shall be listed for hearing on 11th October. Stay tuned with us. The next update is on the Lakhimpur Kheri case. This case, as you know, relates to the incident which took place in Lakhimpur Kheri in Uttar Pradesh in October 2021, where 5 persons were killed after the vehicle of Ashish Mishra, son of Union Minister Ajay Mishra, allegedly ran into a group of farmers who were protesting against the now repealed farm laws. There is a counter case also against some of the farmers for allegedly lynching to death 3 persons, including Mishra's driver. Few days after the incident, the Supreme Court had taken a suo motu cognizance on a letter petition alleging police inaction in the case. In January this year, the Supreme Court granted him interim bail for a period of 6 months. But certain conditions were imposed, which included that Mishra could not enter the National Capital Territory of Delhi and state of UP except to attend the trial court proceedings. Now, Mishra had filed an application seeking modification of the conditions by stating that his mother was admitted to the RML hospital in Delhi and that his daughter needed treatment for leg deformities. Taking a humanitarian view, the bench deemed it appropriate to allow the application. But the court put further conditions that Mishra should not participate in any public function in Delhi and that he should not address the media in relation to this case. In another update, the Supreme Court has constituted a special bench to hear the review petitions against the 2002 judgment in Vijay Mandal Chaudhary case. Through this judgment, the Apex Court upheld the provisions of Prevention of Money Laundering Act, that is PMLA, which relate to power of arrest, attachment, and search and seizure conferred on the Enforcement Directorate. The court had also upheld the twin conditions for bail under Section 45 of PMLA. In August last year, while issuing notice on the review petition, a bench led by the then CJI N.V. Ramanna had observed that two aspects of the judgment prima facie required reconsideration. One, the finding that the copy of the Enforcement Case Information Report, that is ECIR, need not be given to the accused. And the second, reversal of the presumption of innocence. The special bench that will hear the review petitions consists of Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna and Justice Bela Trivedi, and the matter will be heard on October 18th. The Supreme Court today again expressed concerns at central government not deciding on several collegium recommendations for appointments and transfers of High Court judges. The bench comprising Justices S.K. Kaul and Sudhanshu Dholia was hearing a petition filed by the Advocates Association of Bengaluru seeking contempt action against the Union Ministry of Law and Justice for not adhering to the timeline set by the Apex Court in 2021 for clearing collegium proposals, and a writ petition filed by the NGO Common Cause raising the issue of delay in judicial appointments was also listed along with the contempt petition. The fact is that 70 collegium recommendations made by the Supreme Court Collegium from November 2022 are pending with the Union government. And out of them, 7 are names which have been reiterated by the Collegium. A bench led by Justice Sanjay Kishan Kaul shared its concern today with the Attorney General for India, R. Venkataramani, who sought 1 week's time to take instructions from the government. Justice Kaul further said that the bench would take up the matter every 10 days to monitor the progress closely. Interestingly, last year when the Supreme Court issued notice in the contempt petition to Centre, it triggered a confrontation between judiciary and the executive on this issue. If you remember, the then Union Law Minister Kiren Rijiju had used several public platforms to openly question the validity of the collegium system. The comments in return attracted criticism from the court on its judicial side. Also, on a previous occasion, Attorney General R. Venkataramani, on behalf of the government, had assured the court that the timeline for judicial appointments would be followed and the pending collegium recommendations would be cleared soon. Despite this assurance, the Centre has, for instance, not yet notified the appointment of advocates Saurabh Kirpal, Somshekhar Sundaresan and John Satyan, despite the court reiterating their names, rejecting the government's objections. As the Supreme Court will now be taking up the matter on regular basis, stay tuned with us for further updates. The Supreme Court today asked the Enforcement Directorate to not summon Bharat Rashtriya Samiti leader K. Kavitha for questioning in connection with the Delhi excise policy case till her plea challenging ED's summons is heard. You must know that the ED is currently investigating her role in influencing the now scrapped liquor policy in the national capital and related bribery allegations. The investigations are currently underway and have led to the arrest of, among others, Manish Sisodia, former Deputy Chief Minister of Delhi. Today, the bench of Justices Sanjay Kishan Kaul and Sudhanshu Dholia was hearing a plea filed by Kavitha against the summons issued by ED earlier this year, requiring her to appear in Delhi for questioning in connection with the money laundering investigation. Kavitha has argued that she has not been named in the FIR and that the summons were against Section 160 of the CRPC, which protects women from being summoned as witness to any place other than where they reside. Today's senior advocate Vikram Chaudhary, appearing for Kavitha, reiterated his earlier argument requesting the court to protect her from coercive action in the same way as it had protected Nalini Chidambaram, who had approached the Apex Court after the Madras High Court refused to quash the ED summons against her in the Sharad Chit Fund scam case. The court then postponed the matter to 20th November and asked ED not to summon her. In the next update from Supreme Court, it has ordered for status quo to be maintained relating to the appointment of pujaris or priests in agamic temples in the state of Tamil Nadu. Let me give you a short background here. The Tamil Nadu Hindu Religious Institutions Employees Rules of 2020 prescribe the qualification of 1-year certificate course for priests and states that even if a priest has been performing puja for many years, he will not be eligible for appointment in the absence of the certification under the rules. Last year, a division bench of Tamil Nadu High Court held that the rules will not apply to temples constructed as per agamas. The High Court had said that reading down of the said rules was necessary with respect to temples constructed as per agamas to uphold the fundamental rights to practice religion and the rights of a religious denomination to manage its affairs guaranteed under the Constitution. But the said rules were not struck down in their entirety as they dealt with other appointments also. Senior Advocate Guru Krishna Kumar, appearing for All India Adi Seva Sivacharyargal Seva Association, the petitioners submitted before the apex court that despite the High Court ruling, the state was proceeding to make appointments irrespective of denomination, claiming that the priests must have requisite training. The bench of Justice A.S. Bopanna and Justice M.M. Sondaresh issued notice in the writ petition and ordered that status quo be maintained in the matter of appointment of priests in agamic temples. In another update, the Delhi High Court today dismissed a plea moved by climate activist Disha Ravi, who is accused in the 2021 Toolkit case. The plea sought modification of a bail condition requiring her to obtain prior permission from court each time before travelling abroad. In August, the trial court had rejected her application to modify the bail condition. Before the High Court, the Delhi police opposed her plea on the ground that merely because a bail condition is found to be inconvenient cannot be a ground to modify the same. Justice Swarnakant Sharma rejected the petition moved by Ravi seeking modification of the bail condition. The Delhi police's case is that various toolkit documents were circulated on social media during the 2021 farmers' protest, allegedly created by an organization called Poetic Justice Foundation, and that the aim of the creators was to promote disaffection against India, and that the violence during the protest was attributed as being caused by incitement to violence contained in the document, which was allegedly created by Ravi. In the last update for today, the Calcutta High Court has transferred a case relating to alleged illegal seizure of a goods carrier by the West Bengal Police to the state's Crime Investigation Department, that is CID. This was after a clip was played in the court showing recordings of police officers asking for bribe from truck drivers to allow passage through certain police stations in North Dinajpur. The recording was played on record by the petitioner, whose truck had been seized by the police officials. He alleged that the police officers were attempting to extort him and as a result seized his vehicle. The court acknowledged that the veracity of petitioner's claims would have to be forensically verified. At the same time, Justice Jay Sen Gupta said that if allegations made by the petitioner were true, then it would reflect poorly on the state of affairs. Thus, in the interest of justice, the investigation of the case was transferred to the CID, who has been directed to place its report on the recordings played in the court as well as the challans submitted by the petitioner by 17th November. The bench further held that FIRs may be registered against those police officers who are found guilty of the alleged wrongdoings. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.